speech is subject to strict scrutiny? What standard are you asking us to apply?
Justice Greenhouse, not necessarily. It is certainly true with respect to a content-based restriction that applies to adults. The standard starting point is strict scrutiny. Nonetheless, there are two aspects of this statute that render it different from an unconstitutional content-based restriction. Number one, that it applies to minors and only minors. And number two, that it is specifically focused on extremely violent depictions. Beginning with number one, that it applies to minors and only minors, I would suggest the analysis this court applied in the Ginsburg case applies in a very powerful way to this case. In the Ginsburg case, this court upheld a New York statute criminalizing the sale of material that were not obscene. And the court, Justice Brennan writing for the court, no shy defender of the First Amendment, Justice Brennan writing for the court focused on two interests. Number one, first of all, as the court said, constitutional interpretation is consistently recognized that parents claim to authority in their own household to direct the rearing of their children is basic in the structure of society and justifies stronger standards penalizing the sale of what would otherwise be material fully protected by the First Amendment. The second interest was that the state also has an independent interest in the well-being of its youth. Those were the two interests the court focused on in Ginsburg. I would suggest they're precisely the two interests that the California legislature focused on in this case in passing this statute.
Counsel, is there any evidence in the record as to either of those? First, of parents wanting to control their children and being unable to do so in the absence of this legislation, or secondly, that children are psychologically traumatized, depressed, suicidal, losing self-esteem, they're in some way psychologically harmed as opposed to perhaps engaging in some conduct that could harm others?
Yes, Your Honor, there is extensive evidence in the record on both of those questions. With respect to the first questions, parents' inability to protect the children. Right now, the video game system uses a voluntary rating system, and there's voluntary compliance sometimes with it. At the time the legislature acted, the FTC, in a detailed federal study, concluded that a majority of minors could purchase video games that were rated M at the extreme level of the spectrum. And so that was the current federal study at the time, and that was true even for minors as young as 12 years old. A very substantial percentage of them could walk in and purchase video games that had been rated M mature. Secondly, with respect to the harm to the children.
What about evidence of parental preferences? It doesn't say anything about what parents want.
The legislature certainly considered extensively the body of data that exists, and I would suggest also, just as this court did in Ginsburg, that there are some things for which evidence is not necessary. In Ginsburg, the court did not seek evidence, prove to me that parents don't want their children looking at graphic sexual materials. I would also suggest...
Mr. Cruz, I would just say on the Ginsburg comparison that you're making, there was sexual materials, and this court has long said that sexual materials are different from violent materials. And once we go beyond sex and nudity, obscenity to violence, isn't that going to just open so many more doors to other challenges? If you would address the two types of materials here.
Madam Chief Justice, I don't think so, but that gets exactly to the second distinction I was saying this statute has, that it focuses on extreme violence. Now, respondent's position boils down to the proposition that obscenity is unique, and essentially that sex is worse than violence. And I would suggest that that's contrary to common sense. For one thing, consensual sex between adults is legal conduct. It is often salutary conduct. Violence almost always isn't, particularly.
But isn't sex easier to define than violence is? You know, somebody's either naked or not. Somebody, you know, what is violent or not?
It's not necessarily easier to define. I mean, sex, this court has struggled through a long line of obscenity cases to define what is and isn't obscene.
Counsel, Ginsburg spoke about obscene materials in general, didn't specify a particular medium. Here, the state has singled out a particular medium, video games, as opposed to books, music, films, television, does the state have any reason to believe that this one medium is somehow more damaging to young people than the others, or does the state envision eventually extending this statute to cover all forms of media?
There are a number of reasons the state had to focus on this particular medium. For one thing, there has been a proliferation of more and more violent games, which the legislature was looking at. So this statute was drafted particularly to address them. One of the examples, and getting back to the Chief Justice's question, one of the games that is centrally featured here is a game called Postal 2 that invites children to role play beating a little girl with a shovel, decapitating her, lighting her on fire, and urinating on her. Now, I would suggest that no evidence is needed whatsoever for the proposition that a great many parents would be displeased if their children do it.
There's already evidence, for instance, that lyrics, without any images, have inspired some children to take their own lives. Suicide Solution was a song. We've had civil litigation involved after teenagers took their lives directly as a consequence of playing lyrics that encourage them to do so. Why not go further and remove all these dangerous materials from children's access?
Well, the legislature was addressing one problem before it. I would note that video games, unlike music, it can be difficult for parents to tell what is in there. With a song, you can listen to the 5-minute song. When your child buys a CD, you can sit down and listen to it and say, if I don't like these lyrics, you're not allowed to listen to it. With a video game, sometimes the violent activity can be hours or hundreds of hours in, only after you've played at a level of skill that most parents, when they just see the video game, can't tell what's there.
Mr. Cruz, excuse me, these video games, as I understand it, involve the individual, the minor in these cases, with actual interactive involvement in the script, so to speak. Actually manipulating the player to do the violent acts himself in some simulated violence that the individual player is involved in.
That's
Now,
exactly right.
Is that not unlike all of the other examples, particularly the ones mentioned by Mr. Justice Braden, in that it involves active conduct? And does that not have any significance in this case?
Justice Cooper, I think it has critical significance. And what I would suggest, a big part of the dispute in this case is what is the appropriate standard of scrutiny to apply. Respondents urged strict scrutiny. In our briefs, we have urged that the standard this court applied in Ginsburg of rational basis should apply. I would suggest there is also a middle ground to apply, a middle ground of scrutiny. And in particular, respondents argue video games are speech. And I would suggest that that answer is a little too neat, and video games are not pure speech. As a general matter, games are not typically considered speech. Parcheesi is not speech. A basketball is not speech. I would also submit the game of Pong and Pac-Man are not speech. Now, is it true that there are games that have extended narratives and storyline and dialogue that have expressive content? Absolutely. So is there a speech component to some of these games? Absolutely. But I would suggest the analog is far closer to what this court confronted in O'Brien, when you had conduct that had major speech components and non-speech components. And of course, this court held in O'Brien that in that circumstance, intermediate scrutiny applies. Not strict scrutiny, but also not rational basis.
Well, is it your position, Mr. Cruz, then, that the evidence that's in the record in this case could survive the application of intermediate scrutiny? Don't you have to have rational basis scrutiny in order for this evidence to sustain your law?
Your Honor, it is our position that this evidence would easily survive intermediate scrutiny. It would survive rational basis as well, but it would easily survive intermediate scrutiny. There's no dispute that the interests are important interests sufficient to satisfy intermediate scrutiny. In fact, I would submit they're compelling interests sufficient to satisfy strict scrutiny. What the Ninth Circuit focused on was the narrow tailoring aspect under strict scrutiny. Now, we would urge this fits even the narrow tailoring of strict scrutiny, but it even easier and more clearly fits the narrow tailoring requirement of intermediate scrutiny. scrutiny, which doesn't require that it be the least restrictive means available. It only requires that it be the most effective method of addressing the problem. And the California legislature had extensive evidence before it that the status quo wasn't fixing the problem. The kids were able to buy these video games.
Counsel, you mentioned that the interactive nature of the game distinguishes it from other media in answer to Justice Cooper's question. By that logic, could the state also prescribe minors from performing Romeo and Juliet in that play? They would have to engage in sword fighting, suicide, poisoning. They would have to actually embody those things in even a more visceral way than a computer screen. Does the state contend they could also bar minors from performing that work?
The state does not contend that. And this,
How do you define that?
well, at a minimum, this statute was narrowly drawn. The legislature wasn't acting willy-nilly here. It was attempting to embody standards that reflected this court's jurisprudence. So one of the elements of the standards that the legislature adopted is that a violent video game, among other things, is so violent that it causes the game as a whole to lack serious literary, artistic, political, or scientific value for minors. That is, of course, taken directly from this court's decision in Miller and its obscenity jurisprudence. That excludes a whole raft of examples like Romeo and Juliet, like Judge
Mr. Cruz, who's going to make that judgment? To whom do we entrust that judgment? I remember the Chief Justice talking not long ago about not wanting to entrust our First Amendment rights to FEC bureaucrats. Which bureaucrats would you consist of?
I would suggest that judgment would be left to precisely the same individuals that make the judgment today about obscenity. And that is a jury of one's peers looking at the community standards. The video games we're talking about are not video games of a landing at D-Day that the respondent talks about in his brief. They're not video games of Odysseus that Judge Posner talks about. They are games that are at the extreme level. I would suggest they're a video game analog to the Crush films this court considered in the Stevens case. And of course, this court was very careful in the Stevens case not to address the question whether a federal statute that just prohibited Crush films, not that was so broad that it could be applied to hunting as well, but just prohibited Crush films. This court did not address that example. And I would suggest, regardless of what the answer is for adults, it's a much easier question whether the state can act to prevent children from accessing it.
Could you tell us a little bit more about what harm you're asserting this statute protects children from? Because it's quite striking to me. I noticed in the respondents' briefs that even in the decade that video games of this nature have become more and more popular, juvenile crime has plummeted. Juvenile arrests have plummeted. We're not faced with a wave of video game-induced juvenile violence. So I'd like to hear a little bit more about that evidence.
Well, Your Honor, I would suggest those two statements are not necessarily linked. It's true that juvenile crime as a whole has fallen, and there are a host of factors that could well lead to this. That doesn't necessarily mean that video games and extremely violent video games don't promote violence in children. The legislature looked to a number of studies, finding